Surprised to see you out. Surprised to see anyone out so late this night. Just checking the gates. What's outside will, God willing, stay outside. You shouldn't be wandering around here. It's nice. But I'm glad you're here. I've been looking into something that just might interest you. It's the strange case of the extreme emotional distress of Marilyn Manson. The story of a tortured soul who points the finger of blame toward those who pointed the finger at him first. I found some things you might want to see. If you're willing to come inside, I'll share them with you. Manson faces a number of serious allegations by several women. I think it's fair to say that if the jury in the Gore case believed those allegations, believe what Evan Rachel Wood says, Manson's not going to win his case there. Even if he could technically win on some of the claims, who's going to give money, any substantial money, to somebody who did the things that they say he did? So what's going on here? Lawsuits against Manson, and now Manson fires back with his own lawsuit against Wood and Gore, who teamed up to bring the people together who made allegations against Manson and also collaborated on the HBO documentary Phoenix Rising. Manson says that was a conspiracy against him with Wood and Gore, to drag other people in and make false allegations against him. Is that true? He says it was done to ruin his life, his business opportunities, basically to destroy him. And since it's occurred, he suffered severe emotional distress. We're not going to look at tonight the allegations against him. People have done that several times. I've done it several times. What we're looking at tonight is his own claim of severe emotional distress and what he would have to do to sustain it in court. Certain elements he would have to prove to a jury to win that case. That's what we're going to look at. Does he have something there? The guy like Marilyn Manson, with the life he's led, is he going to experience emotional distress because some of the things that were said against him, even if he has lost some business opportunities? Let's go to the law library and see what the elements are and see what kind of case Manson may have. For Manson to win his case, he must establish 4 key elements: outrageous conduct, intentionally or recklessly done, that proximately caused severe emotional distress. Outrageous conduct is defined as conduct so extreme, so terrible, that it's outside the bounds of what a civilized society should accept or tolerate. Intentional or reckless means done with a purpose for, or you just don't care about the probable consequences of your actions. Proximate cause simply means that there's a connection between what the person did, this conduct, and the causation of your injury. Extreme emotional distress in California means the kind of distress that no reasonable person in society should have to tolerate enduring, not a short-term thing, but a horrible level of distress. We'll get into that in particular a little more. So if Manson were to fail on any of these 4 elements and not prove them at trial, his case would fail. He has to prove to the judge that he has a case, and then he has to convince the jury that he has proven his case. Let's see what he has to say about outrageous and extreme conduct. Does he get this first key element? Let's see. Manson alleges in his lawsuit a series of things, and some of those involve the falsifying correspondence from federal agents. mentioning his groupie video and that the actress was a minor, allegedly. Recruiting and coordinating and pressuring women to take part in this campaign against him. So these three things are what I'm going to start with because those are the subject of an anti-SLAPP motion by the defendants because they involve speech activities. So that's not immunity for these to be a basis of the lawsuit. It simply means that for Manson to move forward, he would have to show a probability of success for establishing his infliction of emotional distress claim by using these three things. Now, the judge indicated a great deal of skepticism on two of those. The first was the FBI letter, this false federal correspondence, as Manson alleges, because there's no allegation that it was distributed outside the context of the custody litigation of Evan Rachel Wood's child and her argument with the child's father, that it was used for that purpose and not connected by Manson in any way to himself. He will need to show some evidence to the court for the upcoming anti-SLAPP hearing that that's not the case, or I think the judge is likely to exclude this. As to the recruiting and the messages from Gore to the other women to come join us for this meeting and discuss things that happened and the things that surround that, the judge also indicated that she did not feel like this was extreme or outrageous conduct, that there was not a level of pressuring there, not a level of deception there that could cause this to be considered a basis for an infliction of emotional distress claim. It just was not extreme enough. Those two, to me, shaky ground at best. Now, we'll find out in December when the anti-SLAPP motion is decided, but for now, that's how the judge has indicated that she's leaning. On this other issue of speech, the groupie video, the judge was more circumspect. While she did not see it necessarily applying to Wood, as to Gore, she ordered the deposition of Gore to talk about her intent when she allegedly made these statements. So this one may make it forward, at least as to Gore. But it's not all Manson has for his claim. He has other things that are not subject to this anti-SLAPP motion, so even if those were successful, he'd still have some legs to stand on. Let's see what they are. The first is the swatting that he alleges. He alleges that Gore swatted him by calling the police under false pretenses to come to his house. He also alleges that his private information, personal information, and computer data were accessed inappropriately, that he was essentially hacked by the unwarranted and unsupervised and unpermitted access of his accounts by Gore under the auspices of working with Wood, and that's his allegation there, that they did these things. And of course, in his complaint, he talks about that there were false emails and other things like that. So would these things by themselves be enough? I think the swatting is pretty bad conduct. We shouldn't tolerate that in a civilized society. That is awful. Going into somebody's private data, and that can be criminal, right? That's also something that, maybe by itself, maybe a little bit on the margin, but I still think when you combine it with the other acts that Manson is talking about, that you start to see this pattern here that Manson is trying to say, especially if you combine it with the alleged defamatory statements about groupie. So defamation is also something people don't want to tolerate, particularly given the alleged conduct here involving children. So I see where Manson's going with this, and I think he has enough here, in my opinion, to say that there was alleged conduct, not proven conduct. I'm not saying that these things happened, or all of them, or even under the circumstances he alleges, but as he alleges it, I think he's got enough here to say, I've got a case of outrageous conduct here, at least as to Gore. Whether the judge will pass that over to Wood, since she's not the one that called in the swatting, probably wasn't the one who accessed the computer stuff, and wasn't the one who made the groupie statements. And the judge has already indicated skepticism about that. It may not survive as to Wood, but as to Gore, I think he gets this first key. So this will bookend with the two hardest things, and we'll move to the middle now, the second, which is whether the conduct was intentional or reckless. And Manson alleges that the conduct was intentionally done or with a reckless disregard that he would suffer emotional distress. So the swatting's not going to be an accident, I don't think. You also don't accidentally access someone's computer information and get their social security number and create email addresses with their name on it, things like that. It's not going to be an accident. The groupie video is going to be the subject of this deposition. So this is typically not the hardest element to make, that the acts were intentional or at least reckless. And I think that's clear here. If these acts are outrageous, then it's easy to say that they were intentionally or recklessly done to cause Manson emotional distress, or at least without regard to whether he would experience it based on these acts. I think he gets this key. Let's look at the third. This is also typically a fairly easy one to overcome. Proximate cause. Was the conduct a substantial factor or the proximate cause of the distress that Manson says he's experienced? Well, when you look at the alleged conduct, and then when Manson says, I was not distressed before that, I suffered specific distress after that related to that, this is also a fairly easy one to make. What is the intervening cause? I don't think there will be one. If you don't agree that the acts were outrageous, then these two things won't matter. But if you do, then you will get to the last level, which is whether he suffered severe emotional distress or not. So I'm giving Manson his third key. It's looking good for him. Let's look at the fourth key, maybe the hardest. And that is severe emotional distress. Now, in his lawsuit, Manson made a fairly conclusory allegation of, hey, I suffered severe emotional distress. That's pretty weak. He probably should have gone early in the lawsuit in his complaint with more specific allegations than that. However, he has filed an affidavit that lists some of the things that he says he's experienced. He says, I have felt anxious, distraught, depressed, worried, frantic, sleepless, and fearful for my wife's and my physical safety. Okay, that sounds pretty bad, right? Is that severe emotional distress? Is that severe emotional distress? It sounds awful, but severe emotional distress is kind of a term of art in the law, and it is fairly fluid in every state, and to some degree depends on the judge you get and how they feel about this tort. But let's look at what California has said in a couple of instances and see what kind of judgment that you might make for this. So, in a case where a woman was sexually harassed, she said she experienced discomfort, worry, anxiety, upset stomach, concern, and agitation as a result of the harassing behavior and comments made to her. And the court found that was not severe emotional distress. It was not sufficient to sustain her lawsuit. Those things sound a little bit like what Manson alleged, right? But it's a fairly narrow band there, because here's a case where the court said there was severe emotional distress. In that case, the person felt anxiety and, anxiety, chest tightness, heart palpitations, panic attacks, depression, insomnia, and a diagnosis of post-traumatic stress disorder. Now, that is different than the first case I mentioned. Where do you see Manson's case so far in this? Is it closer to the first case where the court said, no, that's not enough? Is it closer to the second case where the court says it is enough? And maybe it's just too early to say. And I personally think that is the case. Because Manson has alleged this, he's going to be subject to discovery and examination on this. And if it were to go to trial, he could be questioned about it there as well. So the defendants are going to be able to ask him about this emotional distress, so very specifically how his life was before it, how his life has been before, after he started experiencing it, and how it is currently and how it might be in the future. They're going to be able to check his medical records if he's looking at any doctors that are going to sustain his arguments. They may be able to get an order for an independent medical examination. That would surprise me if they aren't, given that the types of things he's alleging. So I think it's too early to say how far he's going to get with this. What if he folded under his deposition and made a very minimal case for emotional distress? It didn't really change his life much. He has said in the past that he's had weird sleep patterns before. So maybe they'll be able to poke some holes in what his life is like now versus what it was before the conduct occurred, whether he's really experiencing severe emotional distress or not. On the other hand, he may shore it up more before a trial. We just don't know yet. I think it is fair to say that if these things are done to you, that it is possible that you could experience severe emotional distress. This is purely on a case-by-case basis, to some degree on a judge-by-judge basis. So in this case, I'm not willing to give him this key yet, but I'm not willing to put it back in this box and say he's completely failed. I think, sorry to say, that it is too early to tell. And that doesn't satisfy people who have already made their mind up about the case. I understand that, but I haven't. Not on particular claims and not on many of the other material things as well. And that's why we have discovery in cases, so that the defendants can probe what the plaintiff is saying and see whether they can poke a hole in it, deflate it, refute it. And it's also why we have a trial, because the people go on the stand, they put themselves in front of a fact finder, potentially here a jury, and they let those people judge the credibility and the weight of the evidence to say, did this person experience severe emotional distress or not, provided that they convince the judge that they at least have a case for that. So I think with his affidavit, maybe he's there so far, but we'll see as it goes through discovery. So what's going to happen in this case next, of course, is the anti-SLAPP hearings will be conducted in December. The judge will issue a ruling. That's likely going to be appealed by one party, and that's going to put the case on ice anyway. But I was asked before to say, what would it take for Manson to prove his case? So I looked at his first claim, obviously infliction of emotional distress, intentional infliction of emotional distress. That's his first claim. I think it's his most dynamic and most central claim. Maybe the hardest claim that he has in terms of the evidence required. And I believe that he has a case for at least 3 of the elements and possibly the 4th, and that one is going to be really important. That's my opinion on that. Now, again, we've got to go through discovery because the defendants may be able to show that the outrageous conduct that he says occurred didn't occur. And if it didn't occur, then obviously his case falls. Again, if he misses any element in this, his case is going to be thrown out. I didn't realize it was so late. I'm going to have to go. So I hope everybody has a happy Halloween. And for those of you who think that lawyers are all bloodsuckers and some form of human vampire stalking the earth, sucking the joy out of society, that's ridiculous. Good night.